Good day, everyone. We're now going to discuss doctrines in corporation law that you need to learn before you go into the bar examinations. These doctrines are based on the decisions of the Supreme Court on corporation law. Let's proceed. Congress shall not, except by general law, provide for the formation, organization, or regulation of private corporations. Based on the case of Philippine Society for Prevention of Cruelty to Animals versus Commission on Audit. Next. GOCCs may be created or established by special charters in the interest of common good and subject to the test of economic viability. The test of economic viability applies only to GOCCs that perform economic or commercial activities and need to compete in the marketplace. Being essentially economic vehicles of the state for the common good, these GOCCs with the special charters are usually organized as stock corporations, just like any ordinary private corporations, based on the case of Republic versus City of Parañaque. Next. When the law vests in a government instrumentality corporate powers, the instrumentality does not necessarily become a corporation, unless the government instrumentality is organized as a stock or non-stock corporation. It remains a government instrumentality exercising not only governmental but also corporate powers. Consequently, government instrumentalities vested with corporate powers and performing governmental or public functions need not meet the test of economic viability. From the case of Mactan Cebu International Airport Authority versus City of Lapu-Lapu. Next. Generally, a corporation cannot recover moral damages because, unlike a natural person, it cannot experience physical suffering or such sentiments as wounded feelings or serious anxiety. The grant of moral damages to corporations is allowed as an exception if there is proof of the existence of the factual basis of the damage and its causal relation to the defendant's acts. Further, a corporation can claim moral damages when it's sued for libel or any other form of defamation, or when the corporation has a reputation that is debased, resulting in its humiliation in the business realm. Based on the cases of First Lepanto Taisho Insurance Corporation versus Chevron, Republic versus Tavera, and Manila Electric Company versus TEAM Electronics Corporation. Next. The revised Corporation Code removed the requirement to incorporate at least 5 incorporators. Next. The revised Corporation Code removed the minimum capitalization requirement for stock corporations. Next. The revised Corporation Code removed the 50-year limit on the duration of a corporate term. Next. The revised Corporation Code requires the corporation imbued with a public interest to allocate certain percentage of their board seats to 2 independent directors. The doctrine of piercing the veil of corporate fiction applies in 3 cases. First, defeat of public convenience as when the corporate fiction is used as a vehicle for evasion of an existing obligation. Second, fraud cases or when corporate entity is used to justify a wrong, protect fraud, or defend a crime. Third, alter ego cases where a corporation is merely a force being a mere alter ego or business conduit of a person. Next, the elements of piercing corporate veil based on the alter ego theory. First, control, not mere majority or complete stock control, but complete domination of finances and of policy. Second, such control must have been used by the defendant to commit fraud or wrong. And third, a forced control and breach of duty must have proximately caused the injury or unjust loss complained of. Next, courts cannot pierce the veil of corporate fiction as against another corporation which is not impleaded in the case. Next, piercing the veil applies to non-stock corporations and natural persons. Next, here a party with a claim against an individual or corporation attempts to be repaid with assets of the corporation owned or substantially controlled by the defendant. Based on the case of International Academy of Management and Economics versus Litton and Company. Next, what is insider reverse piercing? Here, the controlling member will attempt to ignore the corporate fiction to take advantage of the benefit available to the corporations, such as in interest in a lawsuit or protection of personal assets. Based on the case of International Academy of Management and Economics versus Litton and Company. Next, in the absence of provisions in the Articles of Incorporation denying voting rights to the preferred shares have the same voting rights as common shares. Based on the case of Gamboa versus Teves. Preferred shareholders are often excluded from any control, that is, deprived of the right to vote in the election of directors and other matters, on the theory that the preferred shareholders are merely investors in the corporation for income in the same manner as bondholders. Next, common shares cannot be deprived of the right to vote in any corporate meeting, and any provision in the Articles of Incorporation restricting the right of common shareholders to vote is invalid. Based on the 2011 case of Gamboa versus Teves. Next, treasury shares are shares of stocks which have been issued and fully paid for but subsequently reacquired by the issuing corporation by purchase, redemption, donation, or through some other lawful means. It may be held indefinitely, resolved, or retired. While held in the company's treasury, the stock earns no dividends and has no vote in company affairs. Based on the case of Philippine Coconut Producers Federation Incorporated versus Republic. Next, the doctrine of equality of shares states that all stocks issued by the corporation are presumed equal with the same privileges and liabilities, provided that the Articles of Incorporation is silent on such differences. Based on the case of Commissioner of Internal Revenue versus Court of Appeals. Next, the requisites for application of prohibition of the use of confusing corporate name. First, the complainant corporation acquired a prior right over the use of such corporate name. Second, the proposed name is either, first, identical or deceptively or confusingly similar to that of any existing corporation or to any other name already protected by law. Second, patently deceptive, confusing, or contrary to law. From the case of De La Salle Montessori International Malolos Incorporated versus De La Salle Brothers Incorporated. Next, a change in a corporate name does not amount to creation of a new corporation. The doctrine of corporation by ESTOPPEL is founded on principles of equity and is designed to prevent injustice and unfairness. It applies when a non-existent corporation enters into contracts or dealings with third persons, in which case the person who has contracted or otherwise dealt with the non-existent corporation is stopped from denying the latter's legal existence in any action, leading out of or involving such contract or dealing. Conversely, a person who has assumed an obligation in favor of a non-existent corporation, having transacted with the latter as if it was duly incorporated, is prevented from denying the existence of the latter to avoid the enforcement of a contract. Based on the 2018 case of Missionary Sisters of Our Lady of Fatima versus Alzona. Next. The board of directors cannot vote during the board meeting for the payment of compensation for additional duties performed within their powers. Directors of corporation presumptively serve without compensation, so that while the directors, in assigning themselves additional duties, act within their power, they nonetheless act in excess of their authority by voting for themselves compensation for such additional duties. From the 2016 case of Agdao Residence Inc. versus Maramion. Next. A person appointed as general manager by the board of directors pursuant to its authority to appoint officers as it may determine to be proper under the bylaws is not a corporate officer if his position as general manager was not specifically mentioned in the roster of corporate officers in the bylaws. Next. Officers of the corporation are not personally liable for acts as such officers unless it is shown that they have exceeded their authority. Next. If the officer acted without authority but the corporation ratified his actions subsequently or permits him to act with apparent authority, the corporation shall be liable. Next. If by merely error in business judgment, not amounting to bad faith or negligence, loss has resulted, directors and officers are not liable. Next. Director, trustee, or officer of a corporation may be made solidarily liable with it for all damages suffered by the corporation, its stockholders or members, and other persons in any of the following. First, the director or trustee willfully and knowingly voted for or assented to a patently unlawful corporate act. Second, the director or trustee was guilty of gross negligence or bad faith in directing corporate affairs. Third, the director or trustee acquired personal or pecuniary interest in conflict with his duties as director or trustee. Fourth, when a director or officer has consented to the issuance of water stocks or who have knowledge thereof did not forthwith file with the corporate secretary his written objection thereto. Fifth, when a director, trustee, or officer has contractually agreed or stipulated to hold himself personally and solidarily liable with the corporation. And last, when a director or trustee or officer is made, by specific provision of law, personally liable for corporate action. Based on the case of Lanuza Jr. versus BF Corporation. Next. Corporate representatives may be compelled to submit to arbitration proceedings pursuant to a contract entered into by the corporation. If there are allegations of bad faith or malice in their acts representing the corporation. Next. The doctrine of separate juridical entity states that a corporation has a legal personality separate and distinct from that of the people comprising it. Based on the case of Bustos versus Milian Shoes Incorporated. Next. The doctrine of centralized management. As a juridical entity, a corporation acts through its board of directors, which exercises almost all corporate powers, lays down all corporate business policies, and is responsible for efficiency of management. Next. The business judgment rule states that courts are barred from intruding into the business judgments of the corporation when the same are made in good faith. From the 2017 case of Virata versus Sui. Next. Trust fund doctrine. It states that capital stock, property, and other assets of a corporation are regarded as equity in trust for the payment of corporate creditors. Based on the case of Turner versus Lorenzo Shipping Corporation. Next. Illegal corporate acts contemplates the doing of an act which is contrary to law, morals, or public order, or contravenes some rules of public policy or public duty, and are void. They cannot serve as a basis of a court action nor acquire validity by performance, ratification, or estoppel. Ultra vires acts of the corporations are those which are not illegal and void ab initio, but are merely within the scope of the Articles of Incorporation. They are merely voidable and may become binding and enforceable when ratified by the stockholders. Based on the 2016 case of University of Mindanao Incorporation versus Bangko Sentral ng Pilipinas. Next. A preemptive right is the right of a stockholder of a stock corporation to subscribe to all issues or disposition of shares of any class in proportion to their respective shareholdings. The right may be restricted or denied under the Articles of Incorporation and subject to certain exceptions and limitations. The stockholder must be given a reasonable time within which to exercise their preemptive rights. Upon the expiration of the said period, any stockholder who has not exercised such right will be deemed to have waived it. Based on the 2011 case of majority stockholders of Robi Industrial Corporation versus Lim. Next. The validity of issuance of additional shares may be questioned if done in breach of trust by the controlling stockholders. Based on the case of majority stockholders of Robi Industrial Corporation versus Lim. Next. The presentation of a stock certificate is not required to prove one's shareholding in a corporation. It is merely the paper representative of the stock itself and of the various interests therein, based on the case of Insigne versus Abra Valley Colleges. Next. The surrender of certificate of stock is not required before the transfer of shares are recorded in the books. The only limitation imposed by law is when the corporation holds any unpaid claim against the shares intended to be transferred. But the surrender of the original certificate of stock is necessary before the issuance of a new one so that the old certificate may be cancelled. The surrender and cancellation of the old certificates serve to protect not only the corporation, but the legitimate shareholders and the public as well, as it ensures that there is only one document covering a particular share of stock. Based on the 2016 case of Teng versus SEC. Next. What is the effect if there is failure to record the transfer of shares in the book of the corporation? Answer. The stockholder's failure to register the assignment in the corporate books is not fatal to its claim for the delivery of the stocks under the subscription agreement, where the corporation itself unduly refuses to recognize the assignment. Based on the case of Interport Resources Corporation versus Securities Specialists Incorporated. Next. On the death of a shareholder, the executor or administrator duly appointed by the court is vested with the legal title to the stock and entitled to vote it. Until a settlement and division of the estate is effected, the stocks of the decedent are held by the administrator or executor. Based on the 2014 case of Lopez Realty Incorporation versus Tanhanko. Next. Proxy is a form of agency created in instances when a person is unable to personally cast his vote. Hence, the act of voting is delegated to another person. Based on the case of Cesar Riatco Real Estate Services Incorporated versus Bel Air Village Corporation Incorporated. Next. A stockholder who owns only 0.001% of a corporation can demand examination of corporate records. The Corporation Code granted all stockholders the right to inspect the corporate books and records, and in so doing has not required any specific amount of interest for the exercise of the right to inspect. Based on the 2015 case of Terele Investment and Development Corporation versus Yulo. Next. An action for injunction filed by a corporation generally does not lie to prevent the enforcement by a stockholder of his right to inspection. The law provides that access to information is mandatory. Presumption is that the corporation should provide access. If it has basis for denial, the corporation shoulders the risk of being sued and of successfully raising the proper defenses. Based on the case of Philippine Associated Smelting and Refining Corporation versus Lim. Next. The right of descending stockholders to demand payment of the value of their shareholdings cannot be exercised in the absence of unrestricted retained earnings. Based on the case of Turner versus Lorenzo Shipping Corporation. Next. Stockholder of a corporation are liable for the debts of the corporation up to the extent of their unpaid subscription. The creditor can maintain an action upon any unpaid subscription and thereby steps into the shoes of the corporation for the satisfaction of its debt. They cannot invoke the veil of corporate identity as a shield from liability because the veil may be lifted to avoid defrauding corporate creditors. Based on the 2011 case of Haley versus Prentwell Incorporated. Next. De facto merger is where one corporation acquires all or substantially all of the properties of another corporation in exchange of shares of stock of the acquiring corporation. Based on the case of Bank of Commerce versus Radio Philippines Network. Next. The Nell Doctrine. It states that where one corporation sells or otherwise transfer all of its assets to another corporation, the latter is not liable for the debts and liabilities of the transferor. Next. The Nell Doctrine exceptions. First, the purchaser expressly or impliedly agrees to assume such debts. Second, the transaction amounts to consolidation or merger of corporations. Third, purchasing corporation is merely a continuation of the selling corporation. And last, the transaction is entered into fraudulently in order to escape the liability for such debts. Asset sales and stock sales are two kinds of corporate acquisitions. In the 2013 case of SME Bank versus De Guzman, the Supreme Court states that in asset sales, the corporate entity sells all or substantially all of its assets to another entity. In stock sales, the individual or corporate shareholder sells a controlling block of stock to new or existing shareholders. In asset sales, the seller, in good faith, is authorized to dismiss the affected employees but is liable for the payment of separation pay under the law. The buyer, in good faith, is not obliged to absorb the employees affected by the sale, nor is it liable for the payment of their claims. In contrast, the transaction in stock sales takes place in the shareholder level. Because the corporation possesses a personality separate and distinct from that of its shareholders, a shift in the composition of its shareholders will not affect its existence and continuity. Thus, notwithstanding the stock sale, the corporation continues to be the employer of its people and continues to be liable for the payment of their just claims. Next, the term of office of the Board of Trustees in Educational Corporation is 5 years, unless otherwise provided in the Articles of Incorporation or bylaws. Based on the case of Barayuga versus Adventist University. Next, educational institutions cannot secure loans for third persons. It is limited to developing human capital through formal instruction. It is not a corporation engaged in the business of securing loans of others. From the case of University of Mindanao versus Bangko Sentral. Next. The corporation soul is one formed by the archbishop, bishop, priest, minister, rabbi, or other presiding elder of a religious denomination, sect, or church, for the purpose of administering or managing as trustee the affairs, properties, and temporalities of such religious denomination or church. Next. A corporation aggregate formed for the same purpose, that is, administering or managing as trustee the affairs, properties, and temporalities of such religious denomination or church, consist of 2 or more persons. Next, a corporation may change its character as a corporation soul into a corporation aggregate by mere amendment of its articles of incorporation without first going through the process of dissolution. Based on the 2010 case of Iglesia Evangelica Metodista and Las Islas Filipinas Incorporated versus Lazaro. Next. Once a corporation is dissolved, liquidation, which is the process of settling the affairs of the corporation, will ensue. Next. The corporation has capacity to sue after dissolution for a limited 3-year period. Next, a derivative suit is an action filed by the stakeholders to enforce a corporate action. Next, an individual suit is filed when the cause of action belongs to the individual stakeholder personally and not to the stakeholders as a group or to the corporation. An example would be the denial of a right to inspection and a denial of dividends of a stockholder. A class or representative suit may be filed to protect the stakeholders in a group if the cause of action belongs to a group of stockholders, like when the rights violated belong to preferred stockholders. Next. The requisites of a derivative suit. First, the party bringing the suit is a shareholder at the time of the act complained of. Second, he has right to exhaust intra-corporate remedies. Third, no appraisal rights are available for act complained of. Fourth, suit is not nuisance or a harassment suit. And last, The cause of action devolves on the corporation, the wrongdoing or harm having been caused to the corporation. Next. A board resolution is not needed for the institution of a derivative suit. Based on the case of Ago Realty and Development Corporation versus Ago. Next. The regional trial court acting as a special commercial court has the exclusive and original jurisdiction to hear and decide intra-corporate controversies. Next. While the Securities and Exchange Commission has jurisdiction to order the dissolution of a corporation, the Regional Trial Court, acting as a special commercial court, has jurisdiction over the liquidation. Based on the case of Consuelo Metal Corporation versus Planters Development Bank.